Welcome to the deep dive. So, imagine this. A bounced check case, huge amount, 1 crore rupees, but a simple copy-paste error in the demand notice, demanding double 2 crore, actually gets the whole criminal case thrown out by the Supreme Court.
That's right. We're talking about the Kaveri Plastics judgment from 2025. It really drills down into, well, this tension between a technical legal requirement and the, underlying debt.
Exactly, and it all centers on Section 138 of the Negotiable Instruments Act, the bounce check law. Specifically, that demand notice you have to send.
Yeah, that notice is critical. If it's flawed, the whole criminal process just evaporates.
Okay, let's lay out the facts quickly. Check for 1 crore bounces.
Standard stuff so far.
But then the complainant sends out 2 demand notices, one in June, another in September.
Right.
And both of them asked for 2 crore rupees.
Double the actual check amount. And that was the crucial point.
So the person who got the notice, the respondent, they argued, hey, this notice is invalid because the amount's wrong.
And the High Court actually agreed with them. They quashed the complaint.
Which is why it ended up at the Supreme Court. But hang on, why is the exact number so vital? Everyone knew the check was for 1 crore, right? Isn't the debt itself clear?
You'd think so, but the law here, Section 138, Proviso B, is super specific. It says the demand must be for payment of the said amount of money.
Said amount, okay.
And courts have consistently interpreted said amount to mean the exact face value of the check that bounced, nothing else.
But what about things like legal fees or interest? I see those added to notices sometimes. Does that invalidate them too?
Ah, good question. No, that's the key difference. If the notice clearly states the check amount, the 1 crore in this case, and then adds on other separable claims like interest or lawyer's fees, those are generally seen as like extra details. Surplusage, they don't kill the main demand for the check amount.
Got it. So the fatal mistake here wasn't adding extras. It was demanding a completely different main amount, 2 crore instead of 1.
Precisely. That created ambiguity about what was actually being demanded under the statute.
Right. And this brings us to the appellant's argument. They basically admitted the error.
Yeah, they called it a typographical error.
Claimed it happened because of an inadvertent cut-paste command from some other document. They were essentially asking the court to look at the substance, the actual debt.
Look past the typo, basically.
Yeah. But the Supreme Court didn't go for it.
Not at all. And this is central. Section 138 leads to potential criminal charges. It's a penal statute.
Meaning it has to be interpreted strictly?
Very strictly. Literally. The court said there's no question of inferential or implied compliance. You have to follow the letter of the law exactly.
So demanding 2 crore when the check was 1 crore, that just failed the strict test.
Completely. The condition wasn't met. End of story for the criminal complaint.
Even though they admitted it was a copy-paste mistake, that feels quite harsh. Like, oops, CTRL plus C error, case dismissed.
It does seem harsh from a commercial perspective, maybe. But the court emphasized the need for clarity and strict adherence in penal laws, and the fact the error was repeated.
Ah, right, in both notices, months apart.
Exactly. That undermined the simple mistake argument. It showed a persistent failure to meet the statutory requirement. For strict liability, the process is everything. If you botch the mandatory steps,
the case disappears. Wow. Okay, so summing this up for everyone listening, what's the big takeaway?
Well, it's a powerful reminder, isn't it? Especially with things like bounce checks under the NI Act, which involve strict liability. You have to get the paperwork precisely right. Meticulous compliance isn't optional.
Even a seemingly minor admin error, like that copy-paste, can completely let the drawer off the hook criminally, because that initial legal step, the notice, wasn't valid.
That's the crux of it.
Which leads to a fascinating final thought for you to ponder. This principle, strict construction, it's there to protect the accused in criminal law, right?
Yes, fundamentally.
So how vital is it that we keep that principle absolute totally rigid, even in situations like this, where the underlying debt, the 1 crore, seems pretty clear and undisputed?
Does the protection of process outweigh the reality of the debt in these specific penal contexts? It's definitely something worth thinking about, especially when dealing with any legal drafting where precision is paramount.